In this video, we will explore the process related to a lawful permanent resident returning to the U.S. and receiving a notice to appear, addressing potential delays and strategies for mitigating risks. Here's what we'll cover in today's discussion. First, we'll overview the scenario in which a lawful permanent resident returns after an extended absence. Then, we'll dive into what constitutes a notice to appear and subsequently discuss factors that could affect wait times. Following that, we'll provide recommendations for navigating this process. And finally, include a disclaimer. We begin our journey by examining a scenario involving a lawful permanent resident who has been absent from the U.S. for over a year due to unavoidable circumstances like financial hardship or health issues. This individual is considering applying for an SB1 visa to return to the United States. Let's break down what a notice to appear, or NTA, truly means. It's issued by an immigration judge and kicks off the removal proceedings for a returning resident. An important clarification. Getting an NTA doesn't automatically happen with an SB1 visa denial. It generally transpires when a CBP officer decides the lawful permanent resident has relinquished their residence status upon re-entry. Several factors shake up the legal wait times once an NTA is in motion. Jurisdiction plays a big role, where some immigration courts may have pronounced backlogs. Plus, the intricacy of individual circumstances, combined with the evidence's depth and the courtroom resources like judge availability, can all sway processing periods. Let's test your knowledge with a quick question. Which of the following can impact the wait time for a master hearing? Is it A, jurisdiction, B, individual circumstances, C, court resource availability, or D, all of the above? You may pause the video now if you need some time to think. We'll discuss the answer shortly in the next section. The correct answer is D, all of the above. Indeed, jurisdiction, individual circumstances, and the availability of court resources all play a role in extending wait times for a master hearing. Given these challenges, here are some suggested steps to consider. First, weigh the decision regarding the SB1 visa with extreme care, taking into account the risks and documentations needed. Engage with legal counsel if you're facing an NTA to help navigate complexities. Ensure comprehensive documentation supports your extended absence rationale. Lastly, discussing alternative travel options with an immigration attorney can yield additional solutions. To sum up, an NTA isn't a guaranteed follow-up to an SB1 denial. Factors like case complexity and jurisdiction significantly impact the hearing timeline. Seek legal help early and prioritize gathering pertinent documentation. Thank you for watching. If this video provided valuable insight, please like, share, and subscribe. Your interaction helps us bring more informative content your way. Any information provided in this video is meant purely for educational purposes and is not a substitute for professional legal advice. Always consult with a qualified immigration attorney for advice tailored to your specific circumstances.